Tata Consultancy Services Limited versus Cyrus Investment Private Limited, dated 26 March 2021.
Tata Consulting Services is a division of Tata Sons founded on 1st April 1968. It is an Indian multinational IT services and consulting company having its headquarters in Mumbai, Maharashtra, India, along with 46 countries across the globe.
Cyrus Investment Private Limited is a non-government company incorporated on 7th March 1923. It operates as an investment advisor. It's a private unlisted company and is classified as company limited by shares.
Timeline of the event was: in December 2012, Cyrus Mistry was appointed as the chairman of Tata Sons Limited, chosen by a selection panel of Tata Group, when Ratan Tata stepped down from the post.
I'm stepping down from the position of chairman of Tata Sons. Now I want the selection panel to choose a new chairman. You can go ahead with your opinions. I'll be agreeing with that.
Now we decided that with the mutual discussions and majority vote in favor, we choose Cyrus Mistry as our new chairman.
You are eligible.
October 2016. Cyrus Mistry was removed from the post of chairman of Tata Sons Limited by a majority of board of directors for loss of confidence.
Moved me from chairman. Now you'll see how I will leak these documents into the media.
So after this discussion, due to loss in confidence in Mr. Cyrus Mistry, we the Board of Directors has chosen to remove Mr. Cyrus Mistry from the post of chairman with majority votes in favor.
On January 12, 2017, Tata Sons named N. Chandrasekaran as the chairman of Tata Sons Limited and then the TCS Chief Executive Officer and Managing Director. In February 2017, Cyrus Mistry was removed as a director of the board of Tata Sons by the shareholders' vote during the general meeting.
We vote in favor of removal of Cyrus Mistry as board of director now.
Cyrus Mistry filed a suit under Section 241, 242, and 244 of the Companies Act 2013 before National Company Law Tribunal, Mumbai, alleging oppression of minority shareholders' rights and operational mismanagement of the Tata Sons. I allege that Tata Sons abused their powers under few articles and they exercised control over the Tata Sons board. My removal as an executive chairman of Tata Sons board was unjust. There were fraudulent transactions of worth rupees 22 crore in AirAsia by Tata Trust. Transactions made with Siva and Sterling groups of companies by Tata groups were also fraudulent. The losses suffered in Nano Car project clearly depicts the oppression of minority shareholder rights and mismanagement in the group. The accusation of chorus at overpayment by the Tata Trust was unjustified. The verdict given by the National Company Law Tribunal, National Company Law Appellate Tribunal, and the Supreme Court are as follows.
It is decided that all the charges which were made against Tata Sons on the ground that there was oppression of minority shareholders on part of Tata Sons Limited and it had failed to protect and respect the interest of minority shareholders are being dismissed. It has also held that the Board of Directors of Tata Sons have the right to remove Mr. Mistry from the chairmanship. The NCLT elucidated that the act of removal of an employee from the company does fall within the purview of Section 241, which comes into the picture when the affairs of company are conducted prejudicially and are oppressive to the public interest of the company and its members. Since the company is incorporated for the benefit of its members and it is for them to appoint the executive chairman, the claim that they do not have any right to appoint a chairman does not hold merit. Moreover, it has also been acknowledged that the board of directors had lost their confidence in Mr. Mistry. The Article 75 of the Articles of Association of Tata Sons enables it to ask any shareholder to sell his share either to the existing shareholders or to outsiders selected by the board of directors through special resolution. It was argued by Mr. Mistry that the articles oppresses the minority shareholders as they are compelled to sell their shares, which restrict transferability of shares. The Article 75 of the Articles of Association of Tata Sons was waived even before the applicants filed the application in the tribunal, and the applicants were aware of it. In order to prove oppression, the alteration of the Articles of Association need to be done. However, it has not been done in the present case.
It has been observed that Mr. Mistry was removed from the post of chairmanship illegally, and the board of directors did not have a right to remove her on the grounds that such power can be exercised only in exceptional circumstances and in the interest of the company. Moreover, exercising such power reasons for removal should be recorded in writing and intimated to the respective shareholders whose right will be affected. Therefore, Tata and Sons Limited is to reinstate Mr. Mistry, and that appointment of N. Chandrasekharan as the chairman is illegal. While Mr. Cyrus Mistry was removed from his post on the grounds of loss of confidence without any discussions, the records of the company did not show a lack of performance on his part. Therefore, he is to be reinstated after 4 weeks of the date of this order. Whereas the tribunal acknowledged the consequences of Article 75 and therefore orders Tata Sons to not to invoke this provision against the minority shareholders. The conversion from public to private company has been conducted suddenly, and in between the proceedings, the correct procedure for the conversion was not also followed. Therefore, it is held that there was prejudice and oppression against the minority shareholders. It is also clear that mismanagement was very evident as Tata Sons incurred losses because of their prejudicial decisions and resolution passed by the board of directors.
It has been observed that through his conduct, Mr. Mistry himself has invited trouble as he was involved in the leaking of confidential data of the company to media in order to create sensation, and therefore his removal from the post of chairmanship and directorship was justified. It is also observed that mere removal of a person from the post of chairmanship shall not fall within the scope and subject matter of Section 241 if it is not prejudicial to the interests of the minority shareholders. Section 241 and 242 of the Companies Act 2013 do not expressly confer the power of reinstatement. If the action is not prejudicial or oppressive to the interests of the company, its members, or the public at large, the tribunal cannot interfere with the removal of the chairman of a company under Section 241 of the Companies Act 2013.
The 5 year long and the most high profile corporate legal battle between Cyrus Mistry and Ratan Tata gave us the precise definition of Section 241 of the Companies Act 2013 and its applicability. There wasn't a case to begin with. The only dispute that arises from the removal of Cyrus Mistry as chairman of Tata Sons Limited. Cyrus Mistry was only removed from the post of executive chairman of Tata Sons Limited on October 24, 2016 is because the majority shareholders and the board of directors of the company lost confidence in Cyrus Mistry as a chairman, not because by contemplating that Cyrus Mistry would cause discomfort to Ratan Tata.
Excuse me? Where are you going? The case is not over yet.
On 15 February 2022, Cyrus Mistry filed a review petition regarding the case again, and the Supreme Court accepted the appeal.